Hi everyone, today I will be continuing with the court case, and the next couple of episodes we will be going through some of the judgments made on this case. Basically, the judgments made in relation to this case will verify the facts and the evidence already disclosed publicly on my Facebook page and my YouTube channel from 2016 to today. I will be briefly disclosing some of the quotes from the main elements of the case from the actual judgments. However, due to privacy laws, I will not be disclosing the names of any of the parties in this matter at this stage. On the 10th of May 2017, a reserved decision was made by a judge in the district court. This judgment is a 1 to 16 page long, but in this episode I will be taking out portions of the judgment to actually verify the case. Basically, what I'll be disclosing today are actually I've copied it out of the actual original judgment. So when I say quotation, they're all actually from the actual judgment itself. So I will be reading a lot of the what was written in the actual judgment made by the judge. Key issues are as follows. Number 1, whether the plaintiff's statement of claim dated 4th of July 2016 should be strike out. Number 2, amended statement of claim complied with the District Court Rules 2014. Advised to obtain legal advice. So I was actually representing myself at this time, and the judge in the case advised me to get legal representation, but I chose not to. Number 4, an interlocutory application. I'll just pause there. The actual wording and interlocutory application wasn't actually written in the actual judgment, but the actual application was a legal documentation, and I submitted it as an sworn interlocutory application at the time. Along with this application were actually exhibits, but it has been noted in the judgment, but I thought I'd verify that. The actual interlocutory application is called the Notice of Objection for Order to Strike, dated 9th of February 2017, and the defendant's joint submissions dated 23rd of February 2017 was acknowledged. The summary of the claim on the 4th of July 2016. Issues surrounding the drafting of the statement of claim dated 4th of July 2016. Listed 6 defendants. So each defendants were listed and individually on the statement of claim care of the actual company. Number 6, outline of the case. Medical assessments and reports dated 8th of July 2009 and 4th of February 2016. And also, it was also noted, judges noted other issues were cyberbullying, defamation, discrimination, privacy breaches, fraudulent information and detailed and entered, misuse of power and authority by the medical practitioners involved, reputation damaged and suffered humiliation complaint is historical. The District Mental Health Services did not follow through the Mental Health Compulsory Assessment and Treatment Act 1992, was unlawfully enforced and used without relevant or substantial grounds. Number 7, each incident relating to each medical assessments were clearly stipulated in detail of the core elements of the case. Number 8, quotation, paragraph 8. The paragraph numbered 1 states that the plaintiff underwent a mental health assessment and carried out by the 5th and the 6th defendants on the 8th of July 2009. Various details of the assessments are referred to. The 5th and the 6th defendants concluded that the plaintiff did not have any mental health problems apart from her distress, referring what is happening at work. The plaintiff takes issues with other aspects of the assessment, including by referring to other medical records. The relevance of those additional medical records is not really apparent. Number 9, quotation, paragraph 9. Paragraph 2 of the Statement of Claim refers to a second mental health assessment carried out on the 5th of October 2015. Employer's medical assessment by the 4th defendant. The outcome not specified in paragraph 2 was not in the plaintiff's favour, and she was medically terminated from her employment. Paragraph 2 includes various factors the plaintiff takes issues with about the 4th defendant and his assessment, being the 4th defendant's expertise to undertake a medical health assessment, the process by which he prepared his report, no personal contact with the plaintiff. So judges actually noted in her judgment that there was no personal contact, so he didn't see me personally or have a one-on-one consultation with me at any time when he wrote his report. Material he took into account in reading his conclusion, bracket privacy issues, failing to have regard to all relevant facts, the plaintiff's prior assessment of the 8th of July 2009, a quotation, paragraph 10. Paragraph 3 refers to family GP, referring the plaintiff to the District Health Board on the 4th of February 2016 for the said purpose of renewing the plaintiff's medical certificate for work and income. Number 11, quotation, in paragraph 4, the plaintiff claims she was assessed by the 1st and 2nd defendants on the 4th of February under the Mental Health Compulsory Act and Treatment 1992, and she's got in their bracket the Mental Health Act. The paragraph includes a significant amount of alleged facts. As best as I can decipher from paragraph 4 and the surrounding paragraphs, it would appear the 1st and 2nd defendant spoke with the plaintiff because a compulsory treatment order of some sort had been made under the Mental Health Act, and the plaintiff refused to comply with the terms and treatment order, referring to the plaintiff refusing to comply with the arrest to be detained and admitted. Quotation number 12, quotation, paragraph 5 refers to the plaintiff arrested on the 4th of February 2016 by the police officer enforcing the treatment order. Again, the paragraph refers to a significant amount of alleged facts. So this is when I got arrested after the mental health assessment. Number 13, quotation paragraph 13, paragraph 6 refers to a telephone conversation between the plaintiff and her family GP on the 5th of February 2016. So I had a conversation with my family GP because I was very upset about being, referred under the Mental Health Act, and it wasn't my understanding when I had an assessment with her when I went to the doctors, and she referred me for an assessment for the purpose to have my medical certificate renewed. So I rang her the next day from where I was to ask her about it, because I was not happy that they'd used the act on me. 14, quote, paragraph 7 and 8 refer to a meeting on the 5th of February 2016 with the third defendant, who was the clinician responsible for the defendant. Both paragraphs also include a significant amount of extraneous facts Number 15, quotation paragraph 9 refers to an alleged meeting with this guy was he was an ex-co-worker, and also he was an ex-boyfriend, and I had a meeting with him and a nurse. So that meeting's actually acknowledged in the actual judgment, so it did take place. So this ex-co-worker of mine had actually gone through the exact process that I'd gone through, where he was medically terminated, or he was in the process of getting medically terminated, but he got a lawyer in time, and yeah, that changed everything for him. So he was a key witness in this whole thing, because it happened to him, because we both did exactly the same job role, just different location, but we both did exactly the same kind of job. And yeah, so he finished his job before I was, he was the first one to go before me. But yeah, the same thing happened to this person, and he was there to support me at the time. And so I had a meeting with one of the nurses, and the name of the actual nurse we had a meeting with at this time is acknowledged in the actual judgment. So that actually took place. But he was there in support of me, because he knew that I was, what I was going through was wrong. And yeah, and we both knew I was being set up. Number 16, quotation, paragraph 10 refers to a meeting between the plaintiff family members and her immediate medical team on the 9th of February 2016. The purpose of this meeting appears to have been to discuss the extension of the plaintiff's stay in the mental health unit for observation. This paragraph also contains a significant amount of alleged facts. So this I've already mentioned in some of the my YouTube channel, where I had a meeting with one of those doctors, and she wanted to meet up with my family. So this is what this portion, this paragraph confirms, that actually took place. Quotation, the next portion of the statement of claim is preceded by the heading additional information. After the heading additional information are 6 numbered paragraphs that record alleged facts and requests for information. 18, quotation, the final portion of the statement of claim is under the application for relief, and reads as follows. So I'm basically seeking remedy, compensation. That's the end of my statement of claim. And judges noted compensation for pain and suffering, humiliation, defamation, and causing her to go through a life and death set of circumstance. And the plaintiff has substantial evidence to prove that the experiences she's been through is inhumane and deliberate to cause her emotional harm and hurt feelings. So judges also noted that the plaintiff seeks rules section 5.3 for special damages. The recovery special damages, the medical doctors involved in this claim has endangered my life at the point of risk to commit suicide. So what I had actually put in my claim, me being the actual victim, and I was the plaintiff and the actual applicant in this case, so it's my case. But I felt, from the experience I was going through, I felt that the behavior or what I was subject to was absolutely serious and dangerous because one, it was out of my control. I was pushed out. So I was, in the criminal terminology, it's called human trafficking by force because I had no control of the situation. But what they had actually put me through was premeditated. So now as already mentioned, this is all the after the fact issues. But this paragraph confirms how I was feeling at the time when all these incidents was happening, that I have felt, it was very irresponsible and careless and reckless of what these individuals who, were in public office or public office occupation, the decisions they had made. They had put my life in serious duress set of circumstance. That was something I had noted in my claim because of their carelessness, the recklessness of the decisions they made on me. They had, I didn't say, I could have done it, but the risk was there. So I had actually put in supporting evidence to support the danger of what could have happened, because of what they had put me through. I couldn't stop it. And it was just negative. Yeah, till they actually pushed me out, but it didn't even stop there. The next paragraph, the judge noted, the plaintiff has sufficient evidence to prove that on or about 1997, so that's the actual year. So I had actually correlated my medical records historically, and I needed proof to support my allegations and what I was actually saying. So I had all this evidence as exhibits in my case at the time to prove the risk they had put me in. So whether these doctors knew this information beforehand or not, I'm proving my case as they've made me at risk because I'm actually the victim. And, I've been, through so much. And for any individual who's gone through what I've gone through, I can, understand, the pain and the suffering that our victim goes through, that leads to want to commit suicide and then actually do it. It's, and the fact of being ignored and not heard. The carelessness of what these medical practitioners had did was wrong. I don't know what excuse that, they can't excuse what they've done. But anyway, it is noted in this judgment. I'll continue to finish off what Judge wrote. So the year of the actual medical, the year that the actual medical evidence that I'm going by goes far back as 1997, 1998, and this here took place in 2017, or the actual, when I was unfairly dismissed, was December 2015. So continuing with what was on the actual judgment. So I've got 1997 to 1998 was admitted to the name of the hospital because she tried to commit suicide due to family violence with the father of her 3 children. At the time, they were living together when their children were young. She also comes from a dysfunctional background where her father was an alcoholic and abusive. Supporting evidence will be produced before the next hearing. So I've also, at the end of my statement of claim, I've also got a compensation amount I was seeking for what they had put me through. There was a bit of a typing error there, but as time went on, that amount actually progressed because of what they had actually put me through. I've just gone through the first part of this judgment, and basically the judge has taken bits and pieces out of some of the legal documents that she had at the time, and the summary of the actual case from my statement of claim. So she's just verified everything that I've been talking about. So on my next clip, I will continue with the judgment and the decision of that judgment. So I will leave it at that. I hope you've enjoyed this clip and keep watching. You can learn heaps from this whole case as an individual. But while I'm still on this topic, at the end of where we're talking about where I'm seeking remedy, it was really vital for me, to let the judge know the danger that they've actually put me through. The hardest thing it was for me representing myself was because I was the actual victim. And so when you're the actual victim and then try and separate victim and the seriousness, or have that mindset of the seriousness of what was actually happening to me, or have that, serious mindset of being taken seriously about my case, and separating the emotions and what I was, going through with representing myself. It was very difficult for me because I was reliving the actual incidents each time I was dealing with this in court. I was entitled to my justice, but everything I did hit a brick wall because I was subject to something where other people had already made a decision well in advance of what was going to happen to me. But I was determined to go through all this because they'd ruined my reputation, and my case will clearly show that they had taken bits and pieces out of my life and built a case surrounding different incidents that's happened in my life, historical. So that's what's actually happened. But the issue that I was dealing in this statement of claim goes back, to 1997, 1998. So emotionally at that time I was unstable, and I was so much, younger, and rightly so. Things were so difficult for me as the victim compared to what I was going through within the workplace. So the difference was I was not suicidal at any time from between 1998, 1997 to what I was going through. When they used the actual act on me. So they absolutely had no grounds. I wasn't on any medical medication, and they'd have to come up with evidence on the surface to prove that I was unstable emotionally, or so what they've actually done, they've taken little bits and pieces of a word and built a case surrounding it to justify, breaking the law. There's no other word for it. So I'll leave this clip here and watch me on the next clip where I will continue on with this judgment that the judge actually made in 2017. And yeah, so I hope you've enjoyed this clip, and I'll see you in the next episode. Bye.